Now call the second case on this morning's docket. It's case number 115993, State of Kansas v. Ivan Alvarez.
May it please the Court, Sam Shire, appearing on behalf of Ivan Alvarez. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly state the facts for the audience, back in 2016, Mr. Alvarez entered into a plea agreement whereby he would plead to a reduced charge of second-degree murder. At sentencing for that conviction, the district court imposed a 253-month prison sentence, which was predicated upon a criminal history score of D. At sentencing, the district court also ordered court cost relevant to this appeal. Those court costs included a reimbursement order for $421.88 to cover the district attorney's office's expenses for preparing trial exhibits for an anticipated jury trial. Mr. Alvarez appealed, challenging the district court's authority to impose court costs for trial preparation expenses. He also raised a claim contending that it was unconstitutional for the district court to increase his prison sentence on the basis of a criminal history which was not proven to a jury beyond a reasonable doubt. The Court of Appeals rejected Mr. Alvarez's first claim of error and held that the second claim of error, the criminal history challenge, had been inadequately briefed to preserve the issue for appeal. We petitioned those rulings to this court, and this court granted our petition for review. And that is how we got to where we are today. So moving to the court cost issue, to state our claim in a nutshell, we do not believe that the district court has authority to order the state's general trial preparation expenses as court cost. And in making that argument, I want to start out from the premise that a district court has no inherent judicial authority to order court cost. Any authority to order court cost must flow from the legislature through the enactment of statutes. So from that premise, I think the question for this appeal becomes, is there a statute that explicitly says that the state may order court cost for trial preparation expenses?
What does 28172A then contemplate when it gives not only the costs that will be assessed, but it seems to me some flexibility in determining what would be an appropriate cost that's related to a prosecution. Doesn't it do that?
I don't think it does. The part of that statute that the Court of Appeals relied upon, I believe says, all other fees and expenses to be assessed as additional court cost shall be approved by the court unless fixed by statute.
Well, what does that mean?
It means that if something is ordered as a court cost, it has to be approved by the court unless it's fixed by statute. It begs the question, however, of whether an expense may be taxed as a court cost. The way the Court of Appeals decided this...
Excuse me just a minute. But then the next sentence says additional fees shall include and gives a non-exclusive list.
That's exactly right.
Which includes some of the items that I think my colleague was just referencing that look a lot like trial prep.
Well, those are very specific kinds. If you look at...
But whether they're specific or not, I don't think that's really dispositive here because it says specifically they're not exclusive. So then wouldn't we just look at what they are and see if what's being charged here is comparable to them?
I don't believe so, Your Honor. And
Okay.
I say that for two reasons.
Okay.
The first is, the reason this is a non-exhaustive list is because there are a number of other fee statutes scattered throughout the KSAs. This doesn't say anything about BID's attorney's fees. We know those are fees that a district court can impose. There are other fees as well. So the reason this list is non-exhaustive is because there are other fee statutes. The other reason I would say that is because the default position that a district court has to operate from is that it has no authority to order court cost, because there is no inherent judicial authority to order court cost. If there was not a court cost statute, a district court would have no authority whatsoever to order any kind of court cost. So I think that if there is authority to order court cost, it has to come from a statute specifically saying the court has authority to order these particular kinds of expenses as court cost. The non-exhaustive list here just doesn't cover the trial preparation expenses ordered as court cost in this case, the photocopying to prepare trial exhibits.
Why
Why
not?
wouldn't they?
Go
I'm
ahead,
sorry,
yeah, go
why
ahead, Chief.
wouldn't 28172A simply say additional fees shall include those authorized by statute, period?
Why would it not say that, Your Honor?
Yes, I thought you were making the point that you cannot read the trial exhibits photos into this, because what this is referring to is other statutes that authorize the trial judge to assess those as court costs. Did I misunderstand your argument?
I don't believe so, Your Honor. And if I'm understanding the court correctly, my response would be that it's because there is no inherent authority to order the court cost. So it has to come from a particular statute that says, district judge, you can do this.
And so why doesn't the language in 28172A simply say that? And that is additional fees shall be only those that are authorized by statute, period.
It doesn't say that because it doesn't need to, because the default position is that a judge doesn't have authority to order court cost. And I think, again, and I just backtracking to my prior argument, the reason why this is called a non-exhaustive list is because it is. There are other fee statutes. This list provided in 28-172 subsection D does not include all the different kinds of court costs that a different district court can impose. And it certainly leaves open the possibility that the legislature can add additional categories of court costs without going back and amending this statute.
But this list includes things that are not statutory fees, such as doctor's fees and examination and evaluation fees. Are those, so if, does that fact that it includes non-statutory fees mean that by saying it's non-exclusive, they didn't intend to make the non-listed things only statutory?
Your Honor, I would disagree, because I think their inclusion in this list makes them statutorily authorized fees. If something is on this list in the subsection D of the statute we're talking about, it's an expense that can be assessed as court cost. So this list is a list of statutorily authorized fees.
So
As
your
well.
position would be that if it's not listed here in 28172A, it has to be a statutory fee somewhere else.
That's,
If it's a non-statutory fee, I mean, not set by fee, it has to be specifically listed here or it's out of the consideration. If it's
yes.
not covered by a statute somewhere, it's out of consideration.
Yes, that's exactly our position.
So when it says additional fees shall include but are not limited to,
Yes, Your Honor.
that language is referring to the other statutorily authorized cost for the trial judge to assess.
Yes, Your Honor.
And that's all that is, okay.
And the sentence, all other fees and expenses, that sentence that begins with that is only a procedural thing, indication that if the fee is not statutorily set, the court is the one that has to consider what the appropriate amount is.
Right.
So you're not saying that opens up all fees, it only gives us a procedure for what's follows, or what another statute might list as a fee.
Yes. And I think the primary purpose of the subsection D language that we're talking about is just to note that some kinds of fees are fixed. I believe witness fees are $400. Other fees are tied to actual expenses. And so that's the primary purpose of that language. And the problem with how the Court of Appeals viewed this is it just said trial expenses are expenses. And I absolutely agree that trial preparation expenses fit within the plain language meaning of expenses. It's just not the case, though, that this statutory provision says all trial preparation expenses may be ordered as court costs.
Does fee have any independent or different definition than expense? Because it seems to me the nocitur aus sucis or whatever, that it's known by its associates. All of the fees here that I see are some independent third party is charging a fee for a service. And here we're talking about their own expenses that they're generating, office expenses. It's not a fee that has to be paid to anyone. It's operating expenses. So explain to me how that would fit within a fee as we know it, as we understand what a fee is.
Well, Your Honor, as I see things, a fee is whatever the legislature says it is. If the legislature wants to say expenses for preparing trial exhibits may be court cost or may be imposed as fees against a convicted criminal defendant, it could do that, and that would be okay, and those would be fees which could be assessed as court cost. But I just don't see any statute that does that. So that's why I would argue that it's not a fee in this case.
Why isn't the inclusive list here fees that are or costs that are associated with proceeding with the prosecution? Fees like the kit for sexual assault victim, the fees for process of outside the state, transcripts, depositions. Why does that fit it within your definition of what a fee is?
Yes.
And what's the difference between that and a photo expense?
The difference is legislative prerogative. The legislature has said these can be assessed as fees. It hasn't said that trial preparation expenses may be assessed as fees. This is just a pure matter of public policy. The legislature could enact a fee statute that says that the fees ordered in this case were appropriate. I just don't believe that it has. And I'm running low on time for my initial argument. I did want to touch very briefly on the second issue in the petition and in the brief. And I would just respectfully submit that the Court of Appeals, in my view at least, was not seeing the forest through the trees when it ruled that this issue had been inadequately briefed to preserve it for appeal.
Can you step back for me? What occurred here? It wasn't mentioned at the sentencing. In your brief to the Court of Appeals, you attempted to preserve the Ivory issue in a manner that's consistent, that's been done with most cases, it seems to me. And then they said it wasn't properly preserved below.
That's part of the ruling. It's a multifaceted ruling.
And so my question is your Ivory issue preserved for federal review as it stands right now with the Court of Appeals?
I think the answer would be technically no, because they've ruled that we did not raise the issue on appeal, essentially. So that would be the error. Obviously, the Court of Appeals was bound by this court's precedent. I don't think that its ruling in saying that it could not consider the merits of the issue was correct.
And essentially what they said was that you have to fully brief this issue to be adequately preserve the question.
Yes, Your Honor.
Yeah. And that didn't occur here. You didn't fully brief it. which is typical of how the Ivory issue comes before us.
Did you cite the Ivory in your brief?
I did, Your Honor. I would respectfully submit that it was fully briefed because there was really not much to say about this issue to the Court of Appeals. We said, we think this is an Apprendi violation. We said this court has held otherwise, and that the Court of Appeals is bound to follow Supreme Court precedent. I don't know what other information was needed for the Court of Appeals to correctly rule upon that issue. So that's why I believe that particular ruling of the Court of Appeals was erroneous.
Do we have any more questions? Thank you, counsel.
Good morning. May it please the court. Ellen Mitchell, Saline County Attorney on behalf of the state of Kansas today. Starting.
Before you start, can you tell me exactly what we're talking about? The $421.88 was spent for what?
It was spent to, I believe, two vendors, Walgreens and Fast Focus, to develop photos. And the attached document, we attached copies of the credit card statement and the receipt from the businesses. This was an unusual case. This was all photo development. One of the receipts, I think, indicates that there were 1,600 something photos developed. They were all 4x6 photos. This was not any other exhibit preparation other than developing the photos in this case.
And where are they in the record?
The photos?
Right.
They are not in the record because there was a plea.
They aren't part of the trial record here. They were never used.
They were used at a preliminary hearing,
Okay.
but they were not used, and some of
Not
them
offered.
at the plea hearing, they were not.
Okay. And the way this was presented to the district court was in a notice of restitution.
That's correct, and that's poorly worded, and it should have said request for reimbursement or notice
Why
of
aren't you
costs.
bound by why aren't you bound by that? You didn't ask for it to be in the court costs, you asked for it to be restitution. The state's not entitled to restitution.
I agree, we're not entitled to restitution.
And what we're talking about here is this guy's going to prison for 21 years. So you're talking about $422 to begin being paid in payments in 21 years
That's
from
correct.
now. So 5% discount rate, we're talking about $150. And so we're up here arguing about
We are.
$150.
And I thought of that about waiving that, but I decided that the court took the petition for review. They must have been interested in the issue as a whole, not just specifically whether or not, it wasn't the amount that was being contested, it's the whether or not there was authority for it to be entered, because certainly I spent more than that in gas and staying here last night and preparing and that sort of thing. So it wasn't about the amount.
Would those expenses be recoverable?
No. Maybe, I don't know. We're not requesting
I know
those.
that, but I mean that's a ready hypothetical that comes to my mind. Like how elastic is the rule you're asking for?
I don't know that this court has the authority to
I understand.
impose those costs.
Let's
and
say you sought.
Let's say you
Let's say
remanded
you
it.
sought your mileage expenses driving to Walgreens to get the photos developed. I mean, I'm just curious
No.
how elastic the rule is that you're asking for.
No, and actually, no. I will tell you that we use two different places. Walgreens is much cheaper, but
What's
more
the difference between putting the gas bill, the fill up on the county attorney's credit card versus putting the Walgreens photo development on the county attorney credit card? What's the difference?
just trying to be reasonable
So
and not take
Well,
advantage of.
So it's just a discretionary call by the district court. The county can
Correct.
submit any of its expenses.
We don't ask for pens and paper.
I
or
understand you don't ask for it. I'm
fees.
trying to figure out what the legal rule you're asking this court to apply to any decision would be. Would it just be abuse of discretion on the district court's
In determining-
granting of the fees?
In determining the amount, I think the statute says that the court shall, but I think the court has to exercise its discretion, good judgment, as well as the prosecutor's office in what they're requesting.
Well, so we don't typically review the discretion of the prosecutor's office in
Correct.
deciding to ask for these things.
Right.
Isn't the court shall language referred to once a determination made that this would qualify as a cost?
As a cost.
Yeah, but it's not that whatever you request shall be. It's
If the
just
court
once there is a determination this would satisfy the statutory definition of a cost, then it shall be.
It says the cost shall be approved by the court unless the amount is fixed by a statute.
Right.
Counsel, can we start talking about the statute then?
Yes.
You've heard opposing counsel's arguments about how he would like for us to interpret the statute based on the language there and also some authorizing statutes found elsewhere in the code. Could you pick up from there?
I looked at two statutes, or cited two statutes, 223801, liability for costs, and then the 28-172A that talks about starts off by specifying what we typically call court costs, the amounts, and then goes down to the subsection D. If you look at both of those statutes, the legislature said the cost shall be taxed against a defendant and become a judgment, but it excludes in the 3801 statute, you can't come in and ask for jury fees. They're not court costs and they must be paid by the county. And county, you can't be reimbursed for the cost of employing a special prosecutor. But then it says this is a non-exclusive list. This is a sample of what that can be requested. And just as we would have to pay a doctor's fee or an evaluator's fee, we just paid it to Walgreens or to Fast Focus. I don't believe it says it's not an exclusive list, and the legislature did make the effort to exclude some items specifically. And if they could have said the expenses of the prosecutor's office cannot be sought either.
What about counsel's argument that language in 28-172A, additional fees shall include but are not limited to, what the legislature is trying to get at is these are authorized to be paid, the ones that are specifically listed there, and only the ones that are specifically authorized by other statutes.
If you read this line before it, it says all other fees and expenses to be assessed as additional court costs shall be approved by the court unless fixed by statute. And so the state's response would be that it contemplates request for not only fees but expenses. It's right in the line before if you read that whole subsection D together.
Were these, in your view, expenses or fees?
Expenses.
Expenses of what?
Of had we for the preliminary hearing, and then had we actually gone to trial, just to develop the photographs that were in the case to present to the jury.
To present your case.
Right.
And so, presentations can be done in a number of ways. Do you have carte blanche on how you present your case, and any way in which you may want to do it is part of the court cost?
And that might be where the court determines whether or not they're reasonable fees, because these weren't for blowing up giant posters or having something printed.
Where does the statute say the shall be approved by the court if reasonable? It doesn't make any indication like that. And
in the determination of whether or not they're costs.
My problem is all of the exemplars, illustrations, really aren't trial preparation as far as they're not presentation costs. You understand what I'm saying? They're not discretionary kind of.
Well,
it's
examination. If I sent a battered person to our forensic nursing staff at the hospital for an examination and that sort of thing.
Right.
That wouldn't be absolutely necessary. We could use the photographs or we could come in, but we are looking for someone to verify or make our presentation more valid, that the forensic staff or the doctor could say these are injuries consistent with being punched or stabbed or whatever.
So I guess your answer is the governor or the limitation on your what you can include would be the discretion of the trial judge, what the trial judge approves.
To determine whether the trial judge determines if that's a cost.
If any expenses that you may have, if the trial judge determines that he or she is going to approve pens and pencils and legal pads, then if that's approved with your interpretation of the statute, that would be payable.
No, I think that's just the cost of doing a general office cost, such as utilities, staff time. I don't think you can assess overtime for the staff during a jury trial that have to stay late. A portion of the cost of our PowerPoint projector or our laptops, whatever. No, but these are costs that were incurred specifically for this trial.
Counsel, will you address the second issue?
Just briefly, and it's interesting to state in the Court of Appeals opinion, because the Court of Appeals, as pointed out by Justice Rosen earlier, in most of the briefs now that we receive, that's exactly how the Ivory issue is presented, and basically the defendant says we conceded because at this point in time, the Supreme Court, you have to follow their opinion, and there's no evidence that they're going to come off or get away from that statute. And in preparing for this, I thought, I hope this isn't the case where they intend to do that. But it's interesting, though, because the appellate court said that despite a lack of supporting authority or in the face of contrary authority is akin to failing to brief the issue and thus is abandoned. But then, their very last paragraph, they conclude the trial court did not err when it accepted Alvarez's stipulation as to his criminal history and score and then applied it under the KSGA to determine and impose the standard sentence. So it seems inconsistent to the state that they say it wasn't briefed, therefore it's abandoned. The end, they go ahead and make a determination that he stipulated and was appropriately applied.
Do you have any further presentation for us?
I don't.
Any
Thank
more
you.
questions? Thank you, counsel.
May it please the court. There's 2 points I think I'd like to make with my rebuttal argument. The first is that this statute, KSA 28-172A, was likely enacted with the legislature being aware that this court has taken the view that judges have no inherent judicial authority to order court cost, and that the authority to order court cost comes from statute. So with that in mind, I think if they wanted to accomplish a statute which allowed any kind of trial preparation expenses to be ordered as court cost, they would have drafted something to the effect of fees shall include ones which are similar to these set out fees. Instead of using the language shall include but not limited to, which just creates a non-exhaustive list, which is non-exhaustive because there are other fee statutes. The other point that I wanted to make is that these kinds of odds and ends expenses in prosecuting a criminal defendant are somewhat addressed by the general docket fee. The general docket fee is just a fee that applies to every case, and it's based on whether a crime is a misdemeanor, a felony, or a homicide offense. It just is what it is. And it's not tied to any particular expenditures which are documented by the court or by the state. So I think the legislature, in enacting this fee statute, has contemplated that there are just going to be some inherent cost with prosecuting criminal defendants, and that's what the docket fee is intended
But
to.
your opposing counsel contends that this was an expense that was unique to your client's trial. So when you say there's general docket fees to take care of general ordinary costs, her contention is that this was an extraordinary cost because it was applicable, especially particularly to this trial.
Well, I don't think it was extraordinary, Your Honor, because trial exhibits, really exhibits, are the norm, even in cases that don't go to trial. It's normal to prepare exhibits for preliminary hearings. It's normal to prepare exhibits for sentencing hearings. So I don't think anything about the expenses in this case were out of the ordinary for a criminal prosecution. And again, it would just be our position that those extraordinary expenses, if they really were, could have been addressed by the legislature in statute. The legislature could have said expenses like this may be charged as court cost, and it did not.
On that point, in the sentence in 28-172A that says all other fees and expenses to be assessed, what does that "and expenses" refer to in your view?
Well, I think it's saying, I think in that sense, expenses is basically synonymous with fees, Your Honor.
Well, but the very next sentence says additional fees, and it doesn't say additional fees and expenses. So just the syntax of the sentence would seem to me to suggest that fees and expenses are different.
Your Honor, to me, that seems like superfluous language in the statute, and I think what the
Usually we don't interpret statutes to make certain words surplusage. So assume with me that it's not surplusage. There are no other statutes that reference specific kinds of expenses, are there, that can be recouped or charged as court costs?
I
that
don't
word
feel
expenses just is like an orphan in these statutes as far as I can tell. And I'm trying to figure out what that means.
I think what it's trying to get at, Your Honor, is that expenses can, in some circumstances, be set as fees. Expenses can result
Can
in
be
fees.
charged as court costs. That's what it looks like. It says other expenses can be assessed as court costs. And so what are those other expenses? What does that refer to?
And whose expenses? The court's expenses or the prosecutor's expenses? Or the defense? Does defense counsel get to assess exhibits as court costs? I mean,
That's an interesting point, and to be honest, Your Honor, I hadn't contemplated that until this court asked that question. But my fallback position would be that if you just read what the statute says, it says all, and I'm leaving out the word fees, expenses to be assessed as additional court cost. It still doesn't say what constitutes an expense.
Right, but the clear implication, at least, is implicit in this language is that in some scenario somewhere, expenses could be charged as court costs.
Well, again, my position would be only if it's particularly authorized by statute.
And that was my question. Can you think of any statute that uses that word expenses and expressly authorizes those expenses to be charged?
I just don't have a good enough recollection of all the different fee statutes to answer that.
Right. They're
one
fee
way or the
stat.
other.
They talk about fees, not expenses. That's my only question.
Right. There may be statutes that authorize expenses to be imposed as court cost. At this time, at the podium right now, I don't know one way or the other, Your Honor.
Maybe mileage, mileage expenses for witnesses? I mean, we talk about witness fees, but I don't know that mileage expense might be separate from that.
I would think so, Your Honor. I know mileage, but that would depend on the particular wording of the statutes, which I don't have in front of me right now, Your Honor.
And to make it come full circle, the last part of 172 AD says that additional fees shall include costs from other courts.
Costs from other courts.
Doesn't say fees from other courts or expenses from other courts. It says fees. Seems to making it equivalent to costs.
So I would say that cost would be synonymous with expenses, Your Honor. So I'm just, again, my reading of this statute is, it just says that if something is a fee or an expense that can be ordered as a court cost, the district court has to approve the amount unless the statute says what the amount must be. And I see that I am beyond my rebuttal time. Unless this court has any further questions, I'm prepared to conclude argument at this time.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.